The way we're going to work the presentation is you all have copies of you all have a copy of the report. We're going to try and just give you some edited highlights of the report. There's a lot of material in the report, so we've just decided to focus on a few key areas. So what we want to just review, just to remind you really, and to put the piece of work in context, is just the research objectives, an outline of the methodology, how we did it, some context and background for the work, some of the international principles and best practice that we think the Irish agencies need to be tested against, and then to look at a kind of overview at the impact of the cuts. So I suppose if I'm looking at that, that's really the look back and the now. And then the last bit, the questions of independence, conclusions and recommendations, that's us trying to look forward and saying how do we shape and where do we go from here. So I'm going to deal with the look back and the impact of the cuts, and then Brian is going to look at independence, conclusions and recommendations. Okay, so we had 3 research objectives. The first one was to look at the powers provided the powers of the Human Rights Commission and the Equality Authority. Firstly, prior to the cuts, and secondly, following the cuts. And I'm obviously talking about the budget 2008 cuts. We also were asked to develop a methodology to assist the ERA track the impacts of cuts on a rollover basis. So what we've developed is a tracking and indicator system, which you'll find in Chapter 6 of the report. Now, we're not going to deal with that in our presentation. That'll be in the report for anybody who's interested in it. And the final thing then was to make recommendations to address any gaps that we found in relation to protection of rights by either the Commission or the Equality Authority. And that's again in Chapter 6, but Brian is going to give you an overview of that. In terms of the research methodology, the research was carried out over quite a short, intense period of time. We began in May, and we ran through to September, and then obviously in October there's all those changes that you need to make to finalise documents. What we did was we reviewed existing publications, good standards, Paris principles, ECRI recommendations, EU directives, and various evaluations and writings, both in an international and in an Irish context. We interviewed 38 key stakeholders, that most of them were acknowledged in the report. We also then critically looked for engagement with the Human Rights Commission and the Equality Authority. We had a number of interviews with the Irish Human Rights Commission, who subsequently provided information to us. We had less success with the Equality Authority. We had an initial commitment to engagement, but it didn't materialise within the time frame for our research. So obviously we're not as informed as we would like to be from an Equality Authority perspective. In terms of the context and background for the piece of work, we would see obviously the Human Rights Commission and the Equality Authority are core elements of the state infrastructure. They have different origins. The Equality Authority has origins in European equality measures, and the Irish Human Rights Commission in the Good Friday Agreement. Comparisons are possible. There are human rights bodies worldwide. There are principles and guidelines for these bodies. I'm thinking particularly of Paris principles in relation to human rights bodies. There are also a range of equality bodies in the EU, and we were able to speak to some of those equality bodies as part of the research. Then there are also key pieces of international law and practice. There are various equality and race directives, the 2000 directives. There are the Paris principles approved by the UN in relation to human rights bodies. And then there are the ECRI recommendations, which are good practices for equality bodies. So what we tried to do in the research was look at what those particular principles emphasised. What were their core principles that we could look at to examine the effectiveness of the two bodies and the impact of the cuts on the two bodies. So the things that those various documents emphasised were independence, management of your own staff and budgets and having total control of your staff and your budgets, sufficient resources to do their jobs, and even before the cuts there was questions around whether either body had sufficient resources to fulfil their entire mandate. Both organisations, human rights and equality bodies, were to have wide mandates, functions and activities. And one of their primary focuses was to provide aid and assistance that would be accessible to victims. That was one of their most primary focuses. There was to be pluralist representation on the structures that govern these bodies. There was to be engagement with civil society and NGOs on an ongoing, structured and regular basis. And that these bodies were to be accountable to Parliament. They were to be accountable directly to government. And there was to be protection from arbitrary dismissal and some kind of insulation of budgets, so that a decision couldn't be made at a point that, you know, a particular body did a particular thing and funding was cut. So that wasn't part of the principles or guidelines. So in terms of the impacts of the Equality Authority and the Human Rights Commission prior to the budget cuts. The Equality Authority was established in 1999, the Human Rights Commission in 2000, although the Human Rights Commission had a slower start. It was slower for it to acquire premises. So really it was 2002 before it was really fully active. Both bodies were recognised internationally, and you heard Colm this morning saying that he would have heard both bodies getting great praise internationally for the work that they did and recognition for the work that they did. And again, in our consultations, people would have said to us externally, outside of the country, would have said they're models of good practice. They would be suggested as models of good practice. Their impacts, obviously their casework, their assistance to victims and their advice were where the majority of their casework. They were negotiating for change and advising government on bills or on things coming through, and then research, education and information. It was clear from the consultations that some areas of the two bodies' work was less developed than other areas. You can't do everything equally, particularly when we're only talking about bodies that are in place for 10 years. So in terms of areas that were less developed, in the case of both bodies had relations with NGOs, but many of those relations weren't formalised, and there wasn't a kind of structured system for them. There was no system of baseline data. There's been some pieces of work, a piece of work done around equality with the CSO, but in terms of a very structured baseline, and in terms of methodologies for assessing the impact of both bodies, neither of those methodologies were particularly well developed. In the case of the Equality Authority, functions that they would have used much less significantly than others would have been the inquiries, the audits, and the amicus curiae function. Now, I'm not a lawyer or a legal eagle, but as I understand it, amicus curiae is where the body is seen as a body of significance to the court with something to say. So they have a contribution and are recognised by the court as having a contribution to make to court proceedings. In terms of the Human Rights Commission, the casework wouldn't have been as developed. Their inquiry functions, there would only have been a limited number of inquiry functions, and their training and education functions were really only starting to pick up when the cuts were introduced.